Okay, our next segment is going to be Erie and REA. As we near the end. Now, with Erie and REA, what we're talking about is there is a conflict in laws, right? There's a conflict in the law, and we're trying to figure out which law to use, state or federal. So just to remind ourselves, there's two types of conflicts of laws that are at issue in the Erie. And by Erie, I'm speaking very broadly here. RDA, REA, all the various flavors. All right. First, you have the vertical choice of law. That's the one between state court down here and federal court up here. The second one is the horizontal choice of law. Which state? State A, state B, state C, and so on, so on. All right. Erie concerns both of these types of conflicts. Now, regarding the relevant law, if you're going to analyze conflict, you need to think about, well, conflict between what and what, right? So you're going to have to determine the relevant federal law and its scope, and the relevant state law and its scope, all right? Regarding determining the federal law, well, federal law could be various types of law, right? It could be the U.S. Constitution, would be that relevant law.
Yeah.
It could be a federal statute. It could be an REA rule, like a rule of a federal procedure. It could be judge-made law, federal judicial practice, or federal judicial practice, in other words, judge-made procedural law. Or it may be the so-called federal general common law. All right? So we need to determine what law arguably conflicts with the state law. Now keep in mind which category you fall into. In some cases will be clear. In other cases, you might arguably fall into multiple categories, which means you'd have to argue in the alternative. For example, in Hanna, the court gives us a federal judicial practice analysis, the Hanna 1 analysis, right, in dicta, then decides the case based on the Rule Enabling Act. Equally so, in the Walker case, that was a case involving seemingly Rule 3 in state law, right? But the court ultimately says it's not a conflict between Rule 3 and state law, but ultimately analyzes it as if it's a federal judicial practice and state law, right? Also, in the Shady Grove case, we have Justices Scalia and Stevens concluding that Rule 23 conflicts with state law, right? That means they do the REA analysis, Hanna 2. Justice Ginsburg, in a very heated dissent, concludes that what conflicts with state law is not Rule 23, but rather federal judicial practice, and she engages in a Hanna 1 analysis. So that should be a clue to you. If the relevant federal law is clearly on point and is unambiguous, then you'll know what category to be in. So for example, if Rule 3 said, the filing, I'm making this up, it's hypothetical. Suppose Rule 3 said, a civil action is commenced upon the filing of a complaint with the court, and such filing tolls any applicable statute of limitations case, whether state or federal. All right? Got it?
Yep.
Now imagine the facts of Walker, where state law said that you didn't toll the statute of limitations until you actually served the complaint, right? Now, Rule 3 is squarely on point, right? Covers the issue presented. And without a doubt, it would be a conflict between an REA rule, federal rule of procedure, and state law. But instead of Walker, the court says, well, Rule 3 doesn't really cover tolling of limitations, right? In fact, it doesn't say anything about covering, about tolling limitations. It simply says the civil action is commenced upon the filing with the court. So the court in Walker doesn't treat it as being an REA conflict. The court instead treats it as a federal judicial practice conflict, right? So you have to consider, is the federal law that's at issue, how clear is it? If it's unambiguous, then you should know where the conflict, if any, lies. But if the rule is arguably falling into one or more categories, then you need to analyze in the alternative. I think about the arguments made in the Shady Grove case, right? Where the justices analyzed the case both as an REA conflict and as a federal judicial practice conflict. I also encourage you to look at the statements made by Justice Scalia in his opinion and in some of the footnotes, where he talks at length about rules of construction regarding a federal rule. He says things like this, that if the federal rule is unambiguous and speaks to the matter at hand, and we can't read it any other way, then the conflict is between a Rule Enabling Act rule, a federal rule, and state law. All right. On the other hand, if the FRCP, federal rule at issue, is ambiguous, can be read a number of ways, then maybe we analyze this instead under federal judicial practice. So again, look what Scalia says, look at his footnotes, he gives you interpretive suggestions, the opinion, which you should take advantage of. Now, I'm going to get back to this, all right? But remember what I said I wanted to do first is determining the relevant state law and federal law, right? So what I've said has been geared towards determining the relevant federal law. Now let's talk about determining the relevant state law, all right? Well, remember the Claxon case. Two things are needed to determine the relevant state law. One is Claxon, and the second is Eerie case. Claxon tells us that when a federal district court is sitting in diversity, all right, that federal district court needs to use the choice of law principles of the state in which it sits to determine which law to use, okay? And by which law, we're talking the substantive law, all right? So for example, P versus D in Florida for an accident that happened in Alaska, all right? I don't know, imagine P and D are both live in Alaska, the accident was in Alaska, and guess what? D just happens to be in Florida for the summer on a vacation. And for some bizarre law professor hypothetical reason, plaintiff decides to sue in Florida, okay? And gets personal jurisdiction of the defendant by personal service, tag jurisdiction, all right? So we have this case that has pretty much nothing to do with Florida being filed in Florida, all right? All right, suppose it's filed in Florida federal court, fair enough. Which law of negligence will the Florida federal court use? And don't immediately tell me Alaska, because that's not the analysis. What the Florida federal court must do is first ask, what are the choice of law principles used by Florida state courts? And then ask, what substantive law of torts will the Florida state court use? Now, I don't know the Florida choice of law principles. You know, some states use the place of the injury or the place of the contracting, you know, lex loci, the place of the injury, right? Some states use interest analysis and other types of analyses. But let's just assume that a Florida state court would say, under these facts where the accident was in Alaska, between Alaskan residents, we wouldn't use Florida tort law, we would use Alaska tort law. Well, if the Florida courts, under these fact patterns, would use Alaska tort law, then so must the federal court, right? So in other words, when you're a federal court, for the substantive law that's at issue, now use the choice of law principles, all right? If the conflict involves state procedural law, then I'll just give you the state procedural law, all right? I'll just tell you what it is. Well, regarding the substantive law, I said the first thing to do is the Claxon, right? Use the choice of law principles for the state in which the federal district court sits. The second step in determining relevant substantive state law is to do an Eerie prediction, right? Eerie prediction means the federal district court has to ask, what is the relevant state substantive law? Well, if the relevant state Supreme Court has spoken to the issue, and that law appears to still be good, then we use that law. But sometimes the relevant state's substantive law is old, right? And is now been questioned. Or maybe the relevant state Supreme Court hasn't spoken on the issue at hand, right? In which case, the federal district court has to make what's called an Eerie prediction, which it'll look to decisions of lower courts, it can look to law review articles, it can look to the longer trend, and so on and so forth, and make its best prediction as to what the state highest court would decide. It can also certify to the state highest court, but that's not often done because it's very time consuming. Now, last thing to note, on the second step, determining the state law, Eerie prediction is used when the relevant state substantive law is state common law. Don't be tricked that if the fact pattern tells you that the relevant state law is contained in a relevant state statute, all right? This state statute is the end of it, right? We don't do an Eerie prediction if there's a state statute. The federal court doesn't get to ignore a relevant state statute. So, for example, think of the facts of Erie, right? Suppose in Erie, the Pennsylvania legislature had said that a railroad owes a trespasser no duty of reasonable care. Blah, 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 right? Well, Pennsylvania legislature had spoken on the issue. In that case, we follow what the legislature has said. Assuming that Claxon tells us to look to that state's law, and that state's legislature has spoken, then you don't have to do a prediction because the legislature has decided the issue. Okay? Now that we've thought about how to determine the relevant federal law and how to determine the relevant state law, now let's get back into the type of analyses in each of these tracks. Now first, Constitution versus state law. If there is actually a dispute between the U.S. Constitution and state law, all right, let me dial that back 20 seconds, and I want to say one more thing before I move into this listing. Now that you've determined the relevant state law and the relevant federal law, you next need to ask, in fact, maybe I can do it this way. 1, determine federal law. 2, determine the relevant state law, right? 3, do they actually conflict? That's an important consideration. Oftentimes, both state law and federal law can coexist in the same state. They can both be applied without conflict. So one of my questions in my problem set, I think it might be the first one, I have a hypo where there's a federal cyber squatting statute, dealing with domain names, like you go out and register, stthomasuniversity.com, and you use it to put up pictures of a competing university, right? Or you go out and register, Ford.com, and then offer to sell it to Ford, right? You used to read about things like this in the news. It just happened all the time. All right. Well, let's assume there's a federal cyber squatting statute. Let's assume there's a state cyber squatting statute as well, both of which will allow for different amounts of damages, okay? But this is an example of where we have concurrent law, all right? Federal trademark law coexists with state trademark law, all right? And you can have a plaintiff assert counts in the same lawsuit for both federal trademark law, here federal cyber squatting law, and federal and second state cyber squatting law, all right? And both can be sought in the same lawsuit. This happens all the time. Think, for example, an employment discrimination claim, right? P versus D, count 1, federal employment discrimination in violation of Title VII, right? Count 2, federal employment discrimination in violation of the Age Discrimination and Employment Act. Count 3, state employment discrimination in violation of state law prohibits discrimination on the basis of gender or age or race or anything, right? Count 4, a state statute prohibiting age discrimination and so on. These can coexist. So in Eerie analysis, don't simply assume there's a conflict. merely because there's state law and federal law. Once you determine what the state law is and what the federal law is, ask yourself, do they conflict, right? So that's what I wanted to dial up and insert. So the next step is which law to apply, right? And that asks us where we fall in this over here, right? So now, U.S. Constitution versus state law. Suppose the Florida legislature passes a law that anybody that criticizes the government of Florida shall be in prison, right? You know, ridiculous as it sounds, I'm just making it up, all right? Obviously, the First Amendment would render such an act unconstitutional. It would be a serious infringement of our right of free speech. So what's the relevant federal law is the First Amendment, right? Relevant state law, this new Florida statute. Is there a conflict? Yeah. Which law to apply? Well, the federal, right? Because the Constitution, if it conflicts with the state law, the Constitution has to trump it. And you don't have to ask if the Constitution is valid. The Constitution is the law of the land, right? And there you go. Now, what if the conflict is not between the Constitution and state law, but between a federal statute and state law? Well, we have to know, is the federal statute valid, right? Right? So, say for example, we have a case that says, well, I'll just use from the Stewart versus Reichert case, not in your book, I don't think, but the facts are very straightforward. Federal law is the federal venue transfer statute 1404, right? The court may, in the interest of the party, for convenience, the interest of the party, something like that, transfer the case from one district court to another, right? Convenience of the parties and the interest of the witnesses or something like that. Exact wording I can't remember off the top of my head. All right. Imagine a conflicting state statute that had a much narrower basis before any transfer could be made, you know? All right? So you have this conflict between the state venue statute and the federal venue statute, all right? Well, you can't do the constitutional analysis because this is a congressional statute. It's not the Constitution, it's a statute created by Congress under its powers. So all we have to ask here is the statute valid? In other words, is it a valid exercise of Congress's powers? Now, you see this all the time in court decisions. For example, when the Affordable Health Care Act was upheld by the Supreme Court a couple years ago, right? The court upheld the act as being a constitutional exercise of Congress's power to tax, right? Other statutes are upheld or stricken down as being consistent or inconsistent with the Commerce Clause, right? In this class, the relevant provisions of the Constitution that are going to be relevant to procedural statutes are going to be Article 3, which allows Congress to create the lower federal courts, and the Necessary and Proper Clause, which allows Congress to create all laws that are necessary and proper to carry out its enumerated powers. Well, Article 3 is an enumerated power. Congress can create courts. And something that is necessary to create the courts is the power of the federal courts to create procedural statutes. Okay? So as long as the federal statute is arguably procedural, it should be valid. All right? So as long as the federal statute here is valid, it's going to trump a conflicting state law. Very simple analysis. Now, the more difficult analyses are going to be this and this. So let me reserve REA and FJP for a moment. I'm just going to briefly jump down to federal general common law, right? Federal general common law, also known as constitutional Erie. All right? Constitutional Erie is what the court said in the Erie decision when it told us there is no federal general common law. The courts do not have the power to create common law wholesale just because it wants to create common law. Okay? So in Erie itself, it was that holding that the federal court had to apply the relevant standard of care enunciated by the Pennsylvania Supreme Court. It could not create its own favored standard of care. All right, federal courts simply lack that power. The reason we call this constitutional Erie is because if the conflict involves state substantive law versus judge-made common law, well, state law must win. State law must be applied because there is no such thing as federal general common law. Why? Well, for one thing, says the Erie Court, Congress couldn't create such a statute, says the Erie Court. And if Congress can't, the courts can't make it up either. Now, there's a little bit of a caveat to all of this. Even though there's no such thing as federal general common law, federal courts do regularly create federal common law on matters of federal law for federal purposes, right? And we see this all the time. But if the federal court is not creating a federal law from federal bases for the federal purposes, but rather just making up the substantive law to decide a diversity case, it can't do that. It's unconstitutional, and state law must be used. All right? So all that leaves now is REA and FJP. So let me clear some of the boards so I get some board back. REA, Rules Enabling Act. The Rules Enabling Act, it's section 2072, creates, or rather gives the courts the power to create the FRCP and other REA Act rules like the Rules of Appellate Procedure and so on and so forth. All right? If your conflict involves an FRCP on the one hand and state law on the other, then you have to do REA analysis, which is also known as Hanna 2 analysis. And here are the steps I want you to take. So take them. Step number 1 is the FRCP rule constitutional. Step number 2 is the rule of the FRCP valid under the REA. 2 steps. Constitutional? If so, valid under the statute? All right, let's detail each of these. Is the rule of the FRCP constitutional? Well, first, we presume rules of the FRCP to be constitutional. Why? Because the kind of polite way of putting it would be lots of smart people were involved in the creation of the process, but a more nuanced way of putting it is, for a rule of the FRCP to go into effect, it's got to go through the advisory committee, the judicial conference, multiple layers of review. It's got to be reviewed by the Supreme Court, and then the Supreme Court signs off on it. So you have one branch of the 3 code rule branches signing off of it, the Supreme Court. Then it goes to Congress, and Congress also has the opportunity to review it. And these rules go into effect unless within the next 7 months Congress passes a law undoing the new rules, right? So when all's said and done, you have not just the advisory committee and all that stuff. You also have one branch of the government, the Supreme Court, and another branch of the government, the Congress, involved. So the rules are presumed to be constitutional. In fact, for the very same reason, guys, such rules are also presumed to be valid under the REA. But now we get in the meat of the analysis. Presumptions, unless irrebuttable, can be rebutted, right? And these presumptions can be rebutted. So how do we rebut the presumptions? Well, regarding constitutionality, we do the arguably procedural test. That test comes from Hanna, and what the court tells us here, that is that a federal rule of civil procedure is constitutional as long as it's arguably procedural. In other words, says the court, even if the FRCP rule falls in that gray line between substance and procedure, it is constitutional so long as it's arguably procedural. All right? And if you're in that gray area between substance and procedure, then you're like living in both places, right? Which means you're arguably procedural. So make the argument, is the rule arguably procedural? Not a hard burden to make. Regarding the REA analysis, now we actually have to analyze the REA. That's 2072A and 2072B. All right. 2072A tells us the Supreme Court has the power to promulgate rules of practice and procedure in the federal courts, right? And prior cases such as Civic, which is noted in Hanna, which is also rediscussed in Shady Road. This test is met as long as the rule, quote, really regulates procedure, right? So we can see that this is narrower than something that's arguably procedural, right? If arguably procedural, AP arguably procedural is like this, then really regulates procedure, it's got to be a subset of that, right? Now we're concerned not just with whether the rule is arguably procedural, but is it really focused on procedure? Now, really, what does that mean, right? I really don't speed except when I do, right? Adverb alert, what does that mean? So it would seem that the gist here you ought to be thinking about is the main focus here in procedure rather than substance. Maybe that's one way of looking at it, right? Now there's 2072B as well, right? 2072B says that no FRCP can enlarge, abridge, or modify any substantive right, right? It says that. Well, now we have a split in the court. So yay, we're in a Saki zone again, right? Where we don't have a majority rule. Stevens says to analyze, right? He tells us to look at the substantive nature of the state law and ask whether or not it's being messed up by the conflicting federal rule of civil procedure, right? He points out that A and B are distinct subsections, you've got to analyze both. Scalia, for his part, lumps together A and B. He says the really regulates procedure test is the test for both 2072A and 2072B. Now, personally, I think Stevens got the better read, the better argument here, but Stevens didn't get a majority, but neither did Scalia. So you get an essay and you have to do REA analysis, then you need to be ready to talk about both Stevens and Scalia. All right, well, that's REA. Let's move on to RDA and be done with Eerie. That was not so bad. It's really not. It's clear as mud. All right. Now finally, we have federal judicial practice, all right, AKA also known as RDA analysis, RDA referring to the Rules of Decision Act, section 1652. Also known as policy Eerie, also known as Hanna Part 1. All right. The reason this is known as policy Eerie is because this analysis isn't required by the Constitution. Rather, it's a choice made by the courts to err on the side of sometimes using state law, even when the Constitution doesn't require it. So it's not constitutional Eerie, it's policy Eerie. And it doesn't apply in cases where conflicting state law is purely and clearly substantive. Instead, we seem to be dealing with things that fall in that gray area between substance and procedure, right? All right. And the conflict here is going to be between federal judicial practice versus conflicting state law. Now, federal judicial practice, to remind us, what does that mean? Federal judicial practice means judge-made procedural law that's not contained in the Constitution, the federal statute, the federal rule of FRCP, right? It's judge-made procedural law, all right? All right, now here's how I want you to analyze policy Eerie, Hanna 1, whatever you want to call it. Now this I derived from Lannon's book. So here I'm not suggesting to you this is the one and only way to analyze this, but this is the way I'm asking it, like I said in class. I'm saying again, this is how I want you to analyze it in the exam if I ask this of you. All right, step 1, use the York outcome determination test. All right, and here's the handout I gave you. The handout's on the website, isn't it? Yeah, you know the flow chart, circles and all of that? That's on the website, right?
Yeah, I see something.
Yeah. Andrea, look at Andrea over there. She's holding up a handout. Okay. So again, all this stuff is on the website. Again, I have like over 200 pages of materials on that website. It's getting to the point where I can't even remember what I posted to the website. Right. I'm going to go into my own business now. All right. York outcome determination test. The outcome determination test asks, would it have a substantial effect on the litigation to use the federal law instead of the state law, right? So for example, think of the facts of Hanna itself, right? Facts of Hanna itself. If we use the state law, then the case would have to be dismissed because service wasn't made within the relevant time, right? If we use federal service law, at that point Rule 4D, now it would be Rule 4E, then service was proper and the case would continue with a possible victory of the plaintiff, right? So the use of state law versus federal law would be outcome determinative. So under the first part of this analysis, if the answer to this is use federal law, then your analysis would be over, right? But if the answer is, or arguably is, use state law, then you continue to the second step, which is the twin aims of Erie. That comes from the Hanna case itself. The court tells us to look to two things, the risk of increased forum shopping and the inequitable administration of remedies, right? My take on these two is forum shopping is forward-looking, that if federal courts would use federal law, would that encourage plaintiffs to choose federal court instead of state court, right? Is that going to lead to people choosing, hey, we're going federal because they're going to use this law that helps me, right? Inequitable administration of laws, regardless of what Glennon says, my take on it is that it's a normative judgment. Is it just fundamentally unfair to use federal law instead of state law? Thus the word inequitable, right? Unfair. That's how I interpret it. So under step 2, you look at both these things, and if either of them say use state law, then that points towards using state law. So if using federal law would lead to forum shopping, or instead, if it leads to inequitable administration of remedies, that tilts towards using state law. Now, think of the facts of Hanna itself, right? The analysis of Hanna Part 1 is dicta because the case actually involved an REA conflict, but the court very helpfully gives us the RDA, the policy theory analysis, and says, well, and now I'm probably forgetting the exact wording of the case, that I think the court said, expressed skepticism over whether, under the facts of this case, there would be forum shopping. It still felt it would be inequitable to use federal law rather that it wouldn't be inequitable to use federal law rather than state law. That was it. The court said it wouldn't be inequitable to use federal law rather than state law. So if I'm misstating, I apologize, but that's my best recollection. That the court doubted there would be forum shopping, but said regardless, we don't think it would be inequitable to use the federal law. And indeed, in that case, it was just about how the defendant was going to be served. The defendant was an executor of the estate, right? And wasn't really pertinent, so said the court, what the method of service was. If state service was used, then the plaintiff would just as easily have served using the state method of service. I don't know if I completely buy what the court's getting at. What I want you to think about is look at both twin aims, and if either of them tilt towards using state law, that suggests using state law. The final stage of Glannon's, therefore my suggested Hanna Part 1 analysis, is to take a little peek at the Byrd case, as silly as that case is, and ask yourself, even if step 2 says use state law, is there some sort of federal interest, that is sufficiently important, as the court puts it, countervailing federal concern, that would say, even if this step says use state law, then nevertheless, because there's some sort of federal interest, we're going to use federal law anyway. Byrd case doesn't give us much here to go on. Need to take a drink. Here I'll remind you that I have a handout on the website It has excerpts from both York and Byrd, so that'll further guide you on the first and the third step. I said it.
Would it be wrong to analyze the balance first and the twins second or third?
Yes, please don't analyze the balancing first.
I meant second instead of third.
You're saying, you're suggesting analyze balancing second? No, please just keep it this way. Yeah, because the idea here is, this is the first step of filtering, right? If it would change the result to use state or federal law, then who cares if we use federal law, right? But then, even if using federal law would change the outcome, the twin aims test is a little less deferential towards state law. It says, well, even if there's a difference, right, is this going to lead to forum shopping or is it going to be fundamentally inequitable, right? And if that's the case, there's still this kind of, I don't know, safety valve that might allow the use of federal law, so long as there's some countervailing federal interest that's strong enough in using federal law. So yeah, please do it in that order. I guess the final thing to note on the Erie doctrine is, well, heck, with the REA test, it's really deferential towards federal law, right? As long as the FRCP rule is constitutional, which it's almost always going to be, as long as the REA isn't violated, and after shaded growth, it's really hard to violate the REA, right? REA test is generally going to lead towards the application of the federal rule, right? In fact, as the court reminds us, the Supreme Court has never struck down a federal rule as being violative of the REA. On the other hand, the RDA test, and here to be clear, I'm talking about policy Erie, aka Hanna Part 1, regularly has led towards the application of state law. Ginsburg, in her dissent in shady growth, uses the RDA test that says we should use state law. Walker analyzed the conflict as one between a federal judicial practice and state law, and engaging in our Hanna Part 1 analysis, RDA analysis, I said use state law, right? It's much more deferential towards state law, right? And it kind of makes sense when you think it through. Because in the case of Hanna Part 1 analysis, that's what I'm talking about here, RDA, aka policy Erie, there's not a constitutional provision at issue. There's not a federal statute. Congress hasn't spoken, right? There's not an FRCP, in which case the Supreme Court hasn't promulgated the rules subject to the Supreme Court's overview. Instead, it's some judges coming up with procedural law on their own, right? Well, if this conflicting federal law is just judge-made procedural law, maybe we should hesitate a little bit more before using federal law over the state law. So accordingly, this Hanna Part 1 analysis, this policy Erie, is much more likely to lead to the application of state law. Yeah. Okay, I'm going to pause.